Good morning. I hope everyone can hear me nice and clear on this beautiful Wednesday morning. Distinguished entrepreneurs, ladies and gentlemen, I am so pleased to see that so many of you have registered to be educated on this virtual platform today. While finance is critical for SMMEs to survive and grow, most SMMEs seem to be running scared from an overload of administrative tasks, which are costing them double their profit margin. Given the pronounced global financial uncertainties, stable access to appropriate funding sources have become even more difficult for SMMEs to attain. These conditions are constraining their growth cycles and promoting sustainability. That is why CIPC have introduced quick, easy, and effective online processes to reduce long queues and dreary paperwork. Some ground rules before I start. Please mute all your mics and switch off your camera, as this feature affects the bandwidth of the presentation. You are welcome to post questions on the chat group, as my colleagues are available to respond to them. However, at the end of the presentation, we will have a Q&A session. Okay. My name is Shani Kelly, and I'm going to do the introduction. Webinar introduction. CIPC's offerings to enable sustainable business. CIPC was brought into existence by the Companies Act 2008. In terms of Section 185.1 of the Companies Act, the Commission is established as a juridic person to function as an organ of the state within the public administration, but as an institution outside the public service. We have CIPC, Business Corporate Regulations, IP, Intellectual Properties, Innovations, and Creativities. Under corporate regulations, we have companies, cooperatives, and CCs. Under IP, our innovation and creativity side, we have the patents, design, trademarks, and copyright. Okay. CIPC's objectivities. Registration of companies, cooperatives, and intellectual property rights and the maintenance of thereof. Disclosure of information and its registers. Enforcement of the relevant legislation. Something like promotion of education and awareness of company and intellectual properties law, licensing of business rescue practitioners, monitoring, compliance with, and contravention of financial reporting standards and making recommendations thereto. Report, research, and advise the Minister on matters of national policies relating to company and IP law. The director duties. A director must safeguard that a company is properly maintained from a compliance perspective by ensuring these 4 points. 1. The company keeps accurate and complete records. S28. Number 2. Files the CIPC annual returns with the prescribed fee. Point 3. Audit for companies. 4. CIPC of any directors, MOIs, or company address changes within the prescribed period. Okay, I hope that has been informative to you. Now, it is my great pleasure to introduce to you the Corporate Education and Compliance Senior Manager, the Honorable Mr. Silas Marumbo.
Good morning and welcome. Thank you for the opportunity, and apologies, she was trying to set up the presentation. I've already been introduced. I would like to perhaps share with you the nature of how we're going to approach it. As you are aware that there's so many provisions that relates to directors. And my statement on the introduction, which says that many directors in South Africa appear to have a very limited understanding of their fiduciary duties and their duties of care and skill. This is really informed by the fact that as CIPC, we have a low, in some cases, lack of submission of statutory documentation. And you would also agree with me that the current business investigation and cases would confirm that in some areas, one can see that, especially in entry-level companies, people who may perhaps buy a shelf company and just got himself into the business without understanding, and they ended up all this mess that we find ourselves in that situation. Allow me perhaps to, as per invite, to touch also on the question of the qualities of the directors. Most importantly, they are listed, and we will be obviously forwarding you with the presentation itself. Where I don't. Can you hear me? Hello. As I said, if you look at the personal attributes of importance, I think the communication skill, being a strategic thinker, independent thinking, but most importantly, ethical and diligent. And also you making sure that one seeks advice when necessary to understand the area where one is operating, especially relating to the market skills, the industry expertise. If you look at the current pandemic that we're in, how do you ensure that as a director that your institute, your company is also relevant to ensure that you adhere to the changing environment and to be relevant and sustain your business? Let me start by these common law duties in terms of the most essential common law duties, which is namely that one needs to exercise as a director a reasonable care, skill, and diligence. And in this case, one would think of a reasonable man with similar circumstances, how would have handled the matter, or making sure that you take an informed decision. Act in the best interest of the organization, not of yourself in your personal capacity. Act within their powers for a proper purpose. And in this matter, I can perhaps, if you recall the CIPC action that was taken against the SOC, state-owned company SAA, during 2013, where an aircraft deal was, the approved deal was 2 airplanes, and the lease, they ended up having to lease 10 airplanes. And that CIPC found that the director, they've acted in a manner inconsistent with the duties of a director in relation to the 2013 aircraft deal. And hence a compliance notice was served, and also the delinquency application was an option in this regard. Also one of them is also not to accept benefits from third parties, the no-profit rule. We are all aware that currently in the country we have this corruption relates to matters of this nature. You look at the procurement of your hospital equipment, all those matters. Those are some of the things that are impacted by one not adhering to these common law duties. Any failure to fulfill these duties could potentially result in the fiduciary being held liable for damages suffered by the organization or a third party as a result of such failure. The Act requires increased transparency, accountability, and corporate governance requirements. Accordingly, the director duties have increased with greater roles. It is the duty of the company secretary in terms of Section 88, subsection 2 of the Act to keep the directors informed of their duties and obligations as per the Act. Directors are appointed as fiduciaries. As such, they must direct the organization's affairs with duty of diligence, loyalty, and obedience. You would agree with me that it's if one as a director appointed as a fiduciary, this is a relationship of trust. So whatever conduct or behavior must be aligned to the trust that has been entrusted to yourself as a director to ensure that there's fairness and all matters are taken to the benefit of the organization of the company itself. They may be held as directors, you may be held liable for breach of their fiduciary duties in terms of your position of trust. Under the direction of the board, the directors have authority to exercise all their powers and perform their duties as provided by the Act, as well as the organization's memorandum of incorporation. With regard to the director responsibilities, I looked at the sources of director duties. One would be the law itself, the Companies Act. The law, as you're all aware, that we've inherited the English law, and the law is also, in this case, we're referring to decisions that have been taken by the judges as precedent in this regard. As for example, if you look at the state versus Mener Diplom, where ignorance of the law was not an excuse. Those are precedents that informed going forward. The Memorandum of Incorporation being the primary governing document of an organization. This is actually the living constitution of the organization itself or the company. The letter of appointment also, the service level agreement, and the job descriptions, as they could be matters agreed upon between the director and the company that are actually not necessarily within the MOI, but aligned to SPA or service level agreement or your letter of appointment. The rules of the organization in addition to the MOI, but not conflicting with. I think what is important is to take note that whatever is agreed upon in addition as rules should not be in conflict with the MOI of the company itself. The King Codes on Governance for South Africa, taking into consideration King 3, 4, and the updated ones being a set of recommended business guidelines which are recognized internationally. As you know, the issue of making sure that we act in good faith also as a director is aligned to these business guidelines. The courts are testing the validity of the director's actions, as some matters may end up in having to go to our courts. There are three criteria or rules that normally they will take into consideration. One is whether the directors had the authority to act, whether you had the necessary mandate to perform as a director, whatever decision you have taken or conduct in this regard. The director's actions were proper, meaning that they need to be SPO, your MOI's SPO, directive SPO, your mandate. The director's actions were for the benefit of the organizations. As you are all aware that in many cases, actions are taken, but not for the benefit of the organization or the company, but for the benefit of individuals and their families. Those are matters that are currently we see even on the media. However, the legislation makes provision when you look into the directors acting ultra vires, when their actions are beyond the limitation of the power and authority that are permitted by law or the MOI. Where directors act ultra vires and for improper purpose, these actions are invalid and may be liable by the organization for any damages flowing from their breach of duty. The liability may occur in one of the following circumstances. If one breaks the law, the statute itself, breaching or violating a legally enforceable contract, which one would be familiar of in terms of being a director of a particular institution, when an act or failure to act, whether intentionally or not, that also suffices. Being negligent, being also reckless in this regard. And talking of the issue of reckless, one can refer to Section 2 of the Companies Act 2008, which provides for the prohibition of reckless trading. A company must not carry on its business recklessly with gross negligence with intent to defraud any person or for any fraudulent purpose. For example, if one is as a director running an institution or a company, your organization, if you see that the solvency is affected or the assets and liabilities, there's an impact in terms of the company is not doing well and what is required, you can apply your mind that you need to turn around, be through business rescue or whatever intervention that may be required. It is expected of you to ensure that there is no recklessness. You alarm the situation to make sure that in the interest of the company, all matters are up to date. With regard to disqualification of directors or ineligibility, there's 3 points here. Being a juristic person. A juristic person, as you're aware, that you would not have Lucas Standi in your as a company. You will need to be represented by a human being in this regard. An unemancipated minor, if the company specifically in terms of qualifications set out in MOI is not satisfied, that it disqualifies a director. A court has prohibited that person from being a director or declared person to be delinquent in terms of Section 162 of the Act. The unrehabilitated insolvent, prohibited in terms of any public regulation, has been removed from an office of trust, misconduct involving dishonestly, has been convicted in SA or elsewhere for theft, fraud, forgery, and an offense. Delinquent director, in terms of Section 69, Section 30, the Commission is required to maintain a register of delinquent directors and managing members of SCCs. Any member of the public may have access to the delinquent director register, which is kept by CIPC. Information on DDRS and when CIPC is updated on, it's based on judgments, etc. is thus available to all members of the public and any organs of state. Any company that knowingly appoints a director whose name appears on the delinquent register may also be subjected to compliance notices and subsequent legislation. Even I think also in cases where one is sequestrated, they are also within the same list, and normally the period would be 10 years. And how one can have a solution is to pay your debts and also go back and approach the court to ensure that you are removed from such a register. On the Social and Ethics Committee, every state-owned company, listed public companies, and any other company that has in any 2 years of the previous 5 years scored above the 500 points in terms of its public interest score must have a social ethics committee whose role and function is to monitor the company's activities to certain legal requirements or prevailing codes of best practice as set out in Regulation 43, subsection 5. In conclusion, company law has a direct impact on the manner in which both local and global business is transacted. It is therefore critical that South African companies' laws are structured in a manner that seeks to support economic growth, investor confidence, and foreign investment. And on this note, you are all aware that we just made reference to delinquent register, as well as people having trust in our South African directors. They will be able to invest in such companies if really we act and adhere to the rules and regulations as per the Act. As the result, the transparency, accountability, proper corporate governance, and legal and voluntary compliance now play a pivotal role in modern business practice. Allow me to quote Richard Fenley in my ending when he says, I quote, "Sound governance happens only when leaders lead with integrity, when directors actually direct, and when major organizations are held to the highest standards of accountability by vigilant stakeholders and informed individuals." Close quote. Thank you. Over to you.
Right. Thank you, Mr. Marumo. That was very informative. Okay. Now, our favorite part, the questions and answers. Is there any questions that you have? Please raise your hand. It's not raised. Please raise your hand if you have any questions that you would like us to answer. And okay, Lisa. Now, can I please have your question?
Hi there, can you hear me?
Yes, clearly.
Thank you. I just wondered if you can share any specific examples of reckless trading with us, please.
Okay, reckless trading.
I made reference to the state-owned company, the matter of whereby the approved deal was to say let SAA lease 2 airplanes, and then they went and leased 10 planes. So it was recklessly acquisition of additional that which was not as per the director's mandate. Hence, the compliance notice was issued to ensure that the chairperson should have acted according to the approved deal. So, as I said, and I think also just to add, you know that there's a lot of companies in SAA during this pandemic, which could be as a result of so many matters of reckless trading, where you find companies even going for business rescue. So those, but we can also add and check and give you, you can just pop up an email and send to other matters for your interest. Thank you.
Okay. Trista, you can come in any time that you want to answer a question. Okay.
Oh, am I free to do whatever I want like usual? All right. No, reckless trading can be anything whereby you did something reckless. The normal definition of reckless, it is where you trade your company under insolvent circumstances, especially under the current COVID-19. A lot of businesses has got cash flow problems. We have issued a notice for purposes of COVID-19. We are not going to enforce reckless trading on the financial sense, where you're trading your company into under financial or insolvent circumstances. Reckless trading also include acts of whereby you purposefully use your entity to commit fraud, not influence but do harm to anybody else. So it's got a relatively wide definition, but it's also very specific. It must be fraud. There must be an element of fraud and intention to defraud or do something wrong. The Act on Reckless Trading also states that the CIPC has got the authority, when we investigate a claim of reckless trading, is that we can approach the court for liquidation or deregistration of that company or CC. But we can only do that once we have done a formal investigation and we found there were grounds for all of this. And according to my knowledge, unfortunately, our compliance and enforcement team is not here. I don't think we have gone to court yet for any companies for reckless, to have them liquidated based on reckless trading.
Thank you, Krista. I hope that answered Lisanne's question. Okay, the next person. Sipo, can I please have your question?
Hello?
Sipo?
Yes, can you hear me?
Yes, I can hear you. Please tell me your questions. Can I please have your question? Sipo, please unmute yourself and then you can ask your question.
Yes, I just unmuted. Can you hear me?
Yes, I can hear you clearly.
Yes, in the previous years, I started a company with some people. So now I need to know, how do I deregister or close down that company, because I have my own at this moment.
So you are director in another company, and as well as you have your own personal company.
Yes.
Okay, so Sipo, so there's two things here. On the company where you are the sole director, right, you can make the decision to deregister that company. All right. because you're the only director, so you can make the decision, and you follow the normal deregistration procedures, provided that the company is an empty shell, meaning it doesn't have assets or any liabilities. If you owe people a lot of money, deregistration is not going to get you out of your liability with them. You will have to then consider the liquidation process, but that is on our website. So when you are involved with a company where you are one of other, there's other directors, and you want to exit this company, you don't want to be a director anymore. Because the director also has got is also basically an employee of the company. You can submit you need to submit a resignation letter to the company. Remember, because you're ending your employment with the company, and then the company will have to prepare the different documentation that we need, and the company must then submit their Core 39 to the CIPC in order to update the register. Here's the interesting thing. As soon as you have submitted your resignation letter to the company, the effective date in law for your resignation is the date that you've set on that letter. Whether we have been updated or not, your effective resignation is the date on your resignation letter. I hope that helps, Sipho.
Yes, and I think just to add on that, Krista, the resolution itself will also need to have a resolution to that effect. That will be part of this Core 39, as you correctly mentioned. But then people also need a solution.
Yeah, but that's a decision that the company will take after you've submitted your resignation.
Because the company never really worked, so I started mine the following year. So that's why I need to deregister that other one, because no one is active on it.
Are you the only director of the company?
On that other one, I don't remember. It was about 3, if not 4 of us.
Okay. Yes, but
in that case, if there's nothing going, sorry, Mr. Chair, if there's nothing going on in that company, then you need to convene a meeting with that other directors to say, listen, guys, it's time that we apply for deregistration. And if they don't want to do the deregistration, you follow the resignation route as we have indicated, so that you can remove yourself from it. You yourself, as one of a group, cannot make that decision to deregister that company. The other directors still may want to use it in future.
Okay, that's clear.
Great. Okay, please, please note that you can also post your questions on our chat groups. There are colleagues on our group that will answer your question. Okay, Mr. Feldman, your question, please.
Hi, thank you for giving me the time. Also, my question is linked to, Sipho's question, just with regards to people within a non-profit company or company that don't want to be part of the, the company anymore, who's actually resigned from it. What's the process to follow in terms of getting them removed? What's all the documentation? Where do we get it? And, what's needed for that?
Thank you for the question. The documentation is accessible on our website, which will provide the details, but basically you'll just need the Core 39 for resignation of those directors.
Yeah, so with regards to the Core 39, right, it actually also stipulates that you have to have the resolution and minutes and a mandate. Those 3 things, but doesn't the resolution, basically the company resolution, give you the mandate, within the sphere of being in the setting of a meeting to, to remove, the director as such? Because I've tried it that way, and then it was rejected because firstly the mandate, and they wanted the resolution.
Yes, I think that, remember, we also have a CIPC running these processes There are matters where you find other directors saying, I did not give consent to whatever process that happened in the company. Hence, we make it a point, some of these documents are added to ensure that we have a transparent and hold everybody accountable to a process which we can confirm that they were consulted and they agreed to a process. Though it could be some red tape in terms of, but I get your point to say mandate is there, but there's also a process that we need to adhere to, internal process.
Okay, sure. So, Mr. Chair, just the last question in terms of clarity also. So once you have the resignation letter of the person who wants to exit, you have the minutes whereby, it's minuted, whereby it's decided that, this person's resignation has been accepted with all the directors, on board. And then the resolution, the company resolution, do you guys have a standard resolution that you can just download, or do we just do our own company resolution in terms of, say, me being the the main contact, the chair, to actually act on behalf with the communication with CIPC in terms of starting the process to remove the other directors?
Krista, do you perhaps from business respond? As you know that in the past, there's never a standard to that. I mean, if a resolution is taken in terms of format, but yes, the question is that in terms of our work, do we have a standard document that you use for resolution?
All right, here's the thing. You cannot have a cut and paste approach to a resolution. Companies' resolutions can also be taken into different ways and signed off for in different ways in terms of the Act. So, but in theory, the resolution must be signed by the majority of the directors or the shareholders who took the decision. The resolution must also state what was decided. So therefore, you cannot have a cut and paste resolution process. For a valid resolution in law, I'm talking about a resolution, it must state the date, the time, the place. Every company, very interesting, must also number every single resolution. So if this is the decision 50 that the company is taking, the resolution number must actually state there. It must state where it was convened. It must state the purpose. It must state clearly what was decided and agreed upon, and then duly signed by the majority of the directors. That's for the resolution itself.
Yes.
We are having a lot of fraud on companies. To be not fraud, I'm going to correct that. We call it internal disputes, whereby directors keeps removing themselves, each other left, right, and center, in order to take control of the company. And therefore, there's a lot of documentation that are required in order to give CIPC a level of assurance that the company, which is the majority of the directors, have made a specific decision. There is notices on the website that indicates if this type of, is it a resignation, is it a removal, etc., what documents are required. It is specific, and the relevant notices are all on the website that was published by Resignation.
Yeah, so therefore, I think to simplify the answers, that there is no format. It's just to ensure that all the information, as she indicated or stated, are on the document, to ensure that it's a legally enforceable document which have dates signed and the necessary majority is there and all required contents of the information is there. Thank you.
Okay, thank you so much. Just quickly in closing, just to summarize, so in terms of the person resigning from it, you have the resignation letter, you have the company resolution, you have the minutes of the meeting, whereby it's minuted, whereby the resignation is accepted. Are those all the documents needed in terms of the Core 39 process?
Mr. Salman, on our CIPC website, we have all the details of all the documents that you require, as well as all the processes that you need to follow. The CIPC website address is www.cipc.co.za. You can refer to that, or if you have any other queries, you can always email us at education at
Perfect.
cipc.co.za.
But the documents you mentioned are correct. Thank you.
Okay. Excellent. Thank you so much, Jay. Thank you so much.
Okay, right. Ms. Nielsen, Camilla Nielsen, your question, please.
Yes, morning. Thanks for having me. I'd like to know, we registered the company in 2018, but were inactive due to a lot of unforeseen circumstances. So obviously our SARS and everything else is not up to date. And we don't want to lose the company, obviously, because we would like to apply for funding and start trading. What are we to do?
Firstly, you need to check because you're saying that happened in 2018, and if you're not, the company was, one could say, dormant. You need to make sure that the annual returns, the company was complying. Is it firstly to confirm that is it a valid registered company in terms of making sure that your annual returns were submitted and it's a viable company which you can just carry on. You don't have to do anything. Exactly. Because if you don't want it, then instead that you deregister. But the fact that you can proceed and it was on the system is still alive in terms of being up to date and active, then you can just proceed without any problem.
But we don't want to close it. We want to remain active and start trading.
Yeah. As I'm saying to you, if you visit our website, you can just confirm whether your company is still active. Because if you're saying you are not doing anything, I'm not sure as to whether with the annual returns, which is prescribed by the Act, where they paid. And if you know if in cases where annual returns were not paid, you may find a penalty where a company is still registered. So it's very important to confirm the status of the company. That will inform your decision going forward. Once you confirm that, or there's any other matters of assistance, we can, as follow-up education email, send it to us. We'll assist you further. But firstly, in your case, you just have to confirm whether is your company still in business. Thank you.
Okay. Thank you very much.
Okay, great. Once you all have answered your question, please click on the raise your hand button. You can unclick it so that I can see who else has questions. Okay, the next person. Welcome, Lucinda. You are welcome to answer any questions that that is posed. Okay, right. The next person.
Thanks, Shani. Will do.
Nkosita.
Nkosinati.
Your question?
Good morning, thank you. Can you hear me?
Yes, I can hear you clearly.
Yeah, in 2011, I found myself registered as a director into a particular company with the people that I do not know. I brought this to the attention of the CIPC, and some investigator therein was appointed, and it was also brought to the attention of the Tribunal. I also found the person that actually appointed me as a director with those. They found my ID in a photocopy machine somewhere there by Sunnyside. And then I got myself into this company. Till today, I'm listed as the director of that company. I do not know those people. I do not know that company. And unfortunately, the mailbox that I was using to communicate with the CIPC got lost. What do I do to make sure that I'm off that company? Because I see it's still existing, it's not deregistered as yet.
Oh. Lucinda, Krista?
The first starting point is to actually forward your documentation that you've already submitted to the CIPC, that we can identify who's the investigator who is dealing with the matter in CIPC. Investigations does not form part of our central workflow due to the confidentiality of the complaints that's being investigated. So we will, maybe, can I just suggest, Shani, you can confirm whether the specific person can just email the details or give his or her email address that we to you, and that we can just see who was the investigator within CIPC in order to take it further.
Okay. Our email address, you do have it, education@cipc.co.za.
Okay, I'll send my details to that email. Thank you so much.
And we apologize for that, as you correctly said. I mean, this is matter of a fraud. If anything is done without your consent, at CIPC, we always ensure that these matters are handled and resolved. But we'll make sure through your email, follow up and make sure you get attention.
Yeah, because it took me a cool 3 months, 6 months to try and resolve it with the CIPC. I ended up leaving it because I saw on the other side there was no particular action that was happening in the company. So I stayed with the hope that it will automatically deregister if the annual returns are not maintained. I see till today is still in deregistration process. It's not deregistered. And I don't want to be listed as a director of any dealings with that company. I do not know those people. I do not know that company. But thanks, I will submit my details to that email.
Okay. It's very important. It's very important that we need to resolve the directorship. Please do not leave it because it's in deregistration process. In terms of the Companies Act, it clearly states even if a company is liquidated or deregistered, the directors continues having director liabilities post deregistration for actions or inactions taken by that company during its lifespan.
Exactly.
So sorting out the directorship is important because deregistration is not going to take away any liability that a person may have as a director for conduct that happened during its lifespan.
Exactly. That was my concern. I don't want to, when that, for whatever reason, the veil is lifted in terms of separation of jurisdiction person and the legal person and the natural person. When the veil is lifted, I don't want to be affected because I do not know those people. I do not know that company.
Unfortunately, our Commissioner Advocate Rodolfo is very passionate with regard to such matters. We'll ensure that we prioritize it because he always says he would like to have an institution with clean data. And if we have your information in which you never consented to, it's quite a challenge. But we'll make sure, as I'm saying to you, prioritize your matter. Just send us the details. Thank you.
Okay, thank you so much.
Okay. I just need to make something clear. The education email is a personal email. So please do not flood me with questions. If you have a question or you have a query, please log it on our QRS system on the CIPC website. Because when you log a query on our system, you get a reference number. And with that reference number, we are able to track and monitor your question, as well as the fact that your question goes to the relevant department. So please, only questions that we request you to send to education@cipc.co.za. It's very important that you only use those questions. But any other queries, please get a ticket number on our QRS. Yeah. Okay. Right. Okay. The next person. Matloa. Your question, please.
I would like to just check. I think it's just following up on a question that was asked on a Dormant company. I had registered a company last year, 2019. I didn't start trading until now in August. So I just wanted to check. When I went to see there, I saw it's non-compliant. So I just want to understand what is outstanding if it had not been having any activity.
It could be that in all companies in South Africa, in terms of the Companies Act 2008, must ensure that annually you submit your annual returns. So in this case, you'd find that your annual returns were not submitted. But I would also, my colleagues are with me also, they can add in this scenario. It's difficult when you don't have clear facts to say what actually happened. Trista, you can come in also.
Yes, so the likely chances are that it is in deregistration for annual return non-compliance. So please go to the CIPC website or the mobile app and file the outstanding annual returns if it's got a deregistration status. If the status still reflects incorrect, because sometimes we've got another compliance status as well other than annual returns, then please log a ticket via the CIPC website, and we will have to go pull the company records in order to determine what caused the status. But first step is go check the status of annual return filings.
Okay, right. Okay, I hope that answered your question. The next person, Jaku, your question?
Tamasanga, is this one?
Yeah, Tamasanga.
Tamasanga.
Jaku, are you there? Jaku, okay. Tamasang, are you there? Hello?
Yaku here, sorry.
Okay.
Yes, I just have a question. I resigned on a company about 3 years ago, and I handed in my resignation letter, but they have not yet submitted a Core 39 to the CIPC to actually confirm my resignation. And now they requested me, apparently the CIPC cannot register Core 39 if I don't sign the minutes of the meeting. But I've resigned 3 years ago, and the meeting was convened after my resignation. Why do the CIPC require my signature on the minutes if I resigned and weren't part of the meeting?
Okay, Jaco, I think there's a misunderstanding there. If you have resigned in law from the company. The updating lies with the company itself. So it sounds like the company is a non-compliance in effecting the necessary change with the CIPC. You cannot initiate it on your own. In that regard, lay a complaint at COR 135.1 complaints@cipc.co.za. That's the address where people can log or notify the CIPC of any non-compliance by the company with their legal duties. A company has got, I think, 10 working days to effect a directorship change once a director has resigned with the CIPC. So notify us of that with the necessary proof, and then our investigation team that pre-scans this matter can guide you further, or even send it internally.
Okay, and then just another question, or just another point. They sent me a notice that a practice note. They sent me actually CIPC practice note that says, and it also on that practice note say that all parties or all directors must sign that minutes. So I want to make sure, is that including the resigning directors, myself?
Okay, Yaki, that's why I said this thing is a little bit confusing. You have not had any dealings with this company for the last 3 years.
Yes, correct.
Unless you are trying to initiate the directorship change.
No, but I mean, it's on their part. I mean, as you said earlier, my effective date of resignation is the date that I've actually handed in my resignation letter, but they want to initiate it from on their side, but they say they can't. The application keeps on being rejected by the CIPC because I did not sign the minutes of the meeting.
Okay. All right, then the company will have to go log a ticket for the Core 39 team to specifically state what they need under the circumstances. Or you yourself can log a ticket and tell them this is the situation. There seems to be some confusion. What do you need to sign this document that's being submitted? That the company now requires you to submit.
Yeah,
as I stated, the rules regarding directorship changes are very strict because of this unilateral removal of directors vice versa of each other of companies. So unfortunately, we cannot go into the minute details. We can give the overall how to proceed, but the specific details of matters are specific to each case. So I will suggest ask the company to log a ticket and clearly specify what they need, and you yourself can log a ticket to get clarification from the Core 39. Unfortunately, I don't see them here answering questions.
Okay. Okay. Yeah, because it was in terms of that practice note 1 of 2019. That says, okay, but I'll send a ticket then because I mean, I wasn't at the meeting, so I can't sign it. Even if they do send the minute to me to sign it electronically, I can't sign it because I wasn't actually at that meeting. And practice note 1 of 2019 clearly states that all the directors must sign the minutes of the meeting.
If I can just add, Yaku and Krista, I think what happened here, we don't have the query in front of us or the rejection letters, that why it keeps being rejected. But it is correct that a resigning director does not have to sign the minutes of the meeting if he was not resigned at that meeting. But in that case, the resignation letter must be attached. So we need some sort of confirmation that this person actually resigned with his ID and his signature. So it might be that the company did not lodge the resignation letter, but that's, I agree with Krista, so that we can just get to the bottom of this specific case.
Okay, great. And if you don't mind, I'm just going to ask another question. I'm assisting a company to resign a foreign director, but recently the CIPC published a notice or query on one of our applications that I'm assisting a company secretary on to resign a foreign director. They rejected the application due to the certification of the foreign director's passport. This director is situated in the UK, and the query stated that the CIPC does not have jurisdiction over that certification and can't verify it. So we don't know how to actually proceed with the Court 39 to resign the foreign director, because the certification is by a notary that's in the UK, and they've forwarded us a scanned copy of that.
All right, Yaki, the problem that we have is every country in this world has got different ways of requiring certification or notary certification, and we don't carry knowledge of it. So again, in this specific case, you can log a ticket. There is international rules governing the apostillation and legalization and certification of documents. You need to log a ticket for the specific case and tell them, but listen, the certification is not possible, and escalated to higher levels. Please remember that most of the tickets are addressed by administrative teams. So if you're not happy with the response, ask for an escalation higher up into the chain, because the certifications differ country to country, and it's very difficult to determine a set of rules for each country on certification. So sorry, again, this one is a very specific matter where we need more details, and the ticketing system is the ultimate way to go. But again, as I stated, not everybody carries knowledge of foreign certification, so you explicitly ask that it be moved up the knowledge chain to validate that this is a valid certification for that country. Okay, all right. Okay, I'll definitely do that, because they've rejected our application due to the certification being done in a foreign country. So yeah, but I'll just send a ticket then. Thank you so much.
Thank you. Welcome.
Okay, Damasangwa, your question, please.
Good day. I'm struggling to resign from one of the companies that I'm a director of. This other director does not want to give me his certified ID copy so that we can sign the COR 39. So is there another way of doing the resignation without the ID of the other director?
Okay, just clarify your question again, please. Do you want to resign?
I want to resign from this other company. It is no longer active. So CIPC want the form COR 39 to be signed, mandate to lodge, and meeting minutes. They want both our certified ID copies.
Okay, Sandra, just confirm with me. In a case where directors doesn't want to give their cooperation for another one to resign, the matter can be referred to the company's tribunal for adjudication. Is that correct?
Yes, that's correct. But it seems the query is that you, Tamsangwa, doesn't want to give your certified ID copy for submission. Is that the case?
Yes, it doesn't want to give me the certified ID copy because CIPC say they want the form COR 39 to be signed by one of us.
Yes,
but the meeting minutes must be signed also.
Yeah. We need a certified ID copy, and if that person that wants to resign does not want to submit his or her certified ID copy, then the matter can be referred to the tribunal for adjudication by the company itself.
Yes, I agree, because it seems to be more of an internal issue.
Yes, it's malicious to withhold required documentation to finalize certain changes. So if that's the case, we unfortunately cannot do a resignation or anything without the certified ID. If that cannot be obtained, then it can be referred to the tribunal.
How do I get hold of the tribunal?
All the documentation, sorry, Shani, all the documentation on what you need to submit, as well as contact details, is on the company's tribunal website.
Okay, I'll check their contacts.
Okay, thank you very much.
Okay.
Lungile, Zondi? Lungile, you can give me your question.
Unmute yourself.
Lungile, are you still there? Okay, let's go to the next person. Matloa. Matloa, you can give me your question, please.
Thank you very much, and good morning. I just have a question based on this issue of removal of directors. We have a scenario whereby the company that was registered with more than 3 directors, and then when you need to get them to update the CIPC document, they are no longer available, and only to find out that they don't even want to submit the resignation. And then it gives a challenge because their details are still on the system. So my biggest worry is that how long does it take for CIPC to remove a director who's no longer interested or who's no longer in the same shape with the company? Because on a COR 39, most of the cases they came back rejected, and then the requirements, when you follow them, still it does not give you the positive result. So I just want to know from your side, how long does it take to remove a director? And then once the procedures, all the document is filed, and then what's going to happen? Because I still see many companies and that are registered, those old directors are still the ones that are coming on the companies. Thank you. I'll wait for the answer.
Lucinda, are you going to take that question?
Thank you. I'm not exactly sure why the question is directed to CIPC. First of all, there's a huge difference between resignation and removal, and quite different requirements in terms of the Companies Act as well. So the turnaround time from the Director Amendments Division, as far as I'm aware, is a maximum of 5 working days from date of lodgement, if lodged correctly, all the requirements have been met. So I'm not quite sure your query on how long does it take. If an application for resignation or removal, because it's different, is received and everything is in order in terms of the Companies Act and CIPC requirements, it should be done within 5 working days.
And as Lucinda correctly said, in some cases, as you know, especially with regard to removal, you'd find companies seeking a court order, which we are not in control in terms of how long it will take for the matter to be placed on roll and all those legalities that has to do with the matter. Thank you.
Okay, has that answered you? Law? Has that been? Okay. Let's take our next. Let's take our next question. Loretta, can I have your question, please?
Good morning. Thank you for taking my question. I am trying to help a client to obtain a copy of their MOI. It's a non-profit company. The registration number says non-profit. It was registered in 2012. And the copy that somebody gave them then was obviously computer generated, and it gave them a 15-1A. I have then requested copies from CIPC, and I got the copies of the 14.1A and the 14.1 and the 14.3, but not the MOI. And then I submitted another ticket, and via mail, snail mail, I received a set of, once again, computer generated copies, and it once again gave me a 15.1A. I don't know how the company could have been registered in 2012, then it was still the barcoded registration with a 15.1A. And it's very confusing, and I have submitted 6 tickets for this matter.
Okay.
It's firstly we need to apologize in terms of the organizational standards, how we operate matters is very strange, but I think it's to do justice to your matter. It's for you to directly send us the details of that so that we can investigate and follow up. And I can guarantee you, we will make sure that you no longer submit many tickets and all whatever frustration you went through. We are going to prioritize the matter. Just send us the details, please, off-site, and make sure that we resolve your matter. I apologize once again on behalf of the organization. Thank you.
Okay, Loretta, is that clear?
Thank you, Chair. I just also wanted to confirm that you also need to just notify, and then it needs to be escalated to the relevant senior manager for disclosures.
Definitely. Yeah, Shani took note of that. We'll do that. Thank you.
Okay. I'm going to share with you, before I take any more questions, I'm going to share with you a survey. Our survey, and it's on the chat at the moment. Please, it's only 6 questions. Please complete it so that we can evaluate our performance and the importance of this webinar, so that we can decide on whether we need to continue these webinars or if there's any other subjects that you need us to talk about, okay?
And just to add on that, that will assist us as an organization to perhaps make sure that in follow-up webinars, especially as you're aware that with regard to directors, there's quite a number of issues, like for instance, the boards matters, and removals, other matters that you raise, so that we can you can feed us with which areas, which are the gaps within the industry that we need to target, so that when we package our presentations, they must add value and be able to address the issues that say. Thank you.
Loretta, I see your hand is still raised. Have you got another question? Okay, I'm going to take the next question. Matlawe, do you have a question? His hand is still raised.
Hello?
Yes, do you have another question that you would like me to answer?
Yes, I just want to wrap up on what you said. Okay, the challenge that we are facing as the directors of the companies is that when we do things online and when you visited the head office, it's not the same, because there is the tricks and the delays that is being taking place, whereby once you make a follow-up, you find a different information. So I just want to let you be aware of the people which are also doing this for their own gain, because when you come to the CICP, you find that before they assist you, they will also need you to give them money. I mean, that one I want to be honest with you. And then when we try to fix the matter online, it kept on saying we did not submit the relevant document. So please let us give attention on the information that is being received online, and the one that comes straight to your head office, because we got a very serious cases here. Like the guy who said he was involved in a company of which he was not aware. There's people who are doing that, and there's people outside there at the gate that are getting paid, and even the members inside there, they are aware of what is happening. So please, let us deal with those people who are standing there at the door, trying to give people money to get them company registered. There's a person who get a company registered in less than an hour. So the matters like that one, let us try. Let us try. Okay, thank you.
Okay, can I suggest something?
I take note of your concern. However, if you visit the office, you'll find notices that are very clear where we are encouraging the public to say it was a proactive matter that we took as an organization to say, please, we do not have agents for CIPC outside. Those people, we are not in control of them. Make sure that you speak to people. Hence, we make sure that their identification cards are always with them. And also, perhaps going forward, we'll also make sure that we enforce this matter more with our securities within the building to make sure that as customers, we are not affected. That hence, the commissioner always say people should prioritize online transacting, because with online transacting, you are able to detect when your entry application came in and who handled it and why there was a delay, and follow up on tracking of the data. Krista and Lucinda also add anything.
Just to note that everybody should know, we have got a zero tolerance towards fraud. But unfortunately, we need information to act. You cannot say fraud is committed and there's not specific information in order to investigate. On our website, there is a link for a fraud alerts. We have got a department solely responsible for investigating fraud allegations like those matters. But we need sufficient information in order to properly investigate. So if you come across such an incident whereby a staff member, you know about a staff member that is expediting applications, or a customer outside, the people outside, they are not excluded from this process. You can log the fraud alert with enough sufficient information in order to trace it. We usually appoint service providers to help us with all of these investigations, and then our investigation team will then investigate, and if necessary, we will take criminal action, disciplinary action, or even correction of the data if need be. But we need the fraud alerts in order to come in order to attend to those. But thank you for raising that.
Okay. Thank you, Krista, so much for that. Lucinda, your hand is raised. Is there anything that you want to add?
Yes, thank you, Shani. I just wanted to add that and echo what Maruma has said, is that unfortunately we have no control over those people standing outside of the DTIC campus. So every single client of the CIPC has a responsibility to make sure that they transact only with CIPC employees. If they fall for those getting all your work done within an hour for 500 Rand or whatever the case may be, then that is that person's responsibility. If they did not show them an identification that they are working for the CIPC, then we cannot be held responsible for using such persons to do your changes. Number one. Number two, if echo what Krista has said, if you had dealings with an CIPC employee that requested monetary compensation for assisting, then that must be immediately reported so that it can take on in the appropriate matters that we have indicated. But we require diligence from our clients to make sure that the person that you are transacting with is in actual fact a CIPC employee, and you are more than welcome to ask identification if you are working directly with such a person. Okay, thank you.
Thank you.
Okay, Matloa, that answered your question. You can put down your hand. Santi, you have a question?
I do. Can you hear me?
Yes.
Yes, I can hear you.
I have also put the question in the chat earlier on. I just want to check. Very often, a couple of people would form a company and then nothing ever happens with the company, and eventually the people lose contact with each other. If a person that was a director of such a company wants to resign from that company, but is not able to contact or even trace the other directors, how do they then detach themselves from that company?
Okay, so you there was a company created and you're one of the directors of the company, but you don't know how to contact any of the other directors in order to resign. Am I correct?
Correct.
And did you try to trace and to try and get hold of them in terms of making sure that the necessary documentation consent is obtained?
Yes.
And there is cooperation amongst yourself and them? Because I'm asking this question because remember, there are matters, and my colleagues, both advocates would agree with me that in some of the cases you'll find one seeking a court order where there is no cooperation. But Lucinda can take it further from there. Thank you. Lucinda?
Lucinda, can you answer the question, please? Okay, I seem to have lost Lucinda. Krista, are you available? Okay.
Sorry, guys, I just lost connectivity there for a second. Could you repeat the question, please?
The question is, if a person has lost all contact with a company that is never traded, the company basically was formed, it's never traded, and the people, all the directors have lost contact with each other. So, for all intents and purposes, that nobody is contactable to resign from a company. And if a director wants to resign from such a company, what do they do if they are not able?
You have background.
There's a lot of background noise. Okay. Lucinda, please unmute yourself.
Sorry, guys, I was talking to myself there for a second. If something like, it seems like there is no contact by any of the directors, I think first step would be to check if this company hasn't been deregistered already due to inactivity and annual return non-compliance. And then second of all, there can be made a specific effort in contacting these other directors to do the resignation, or the resignation can be filed yourself. I know that the Director Amendments Division also accepts affidavits commissioned by the police confirming that relevant attempts have been made to get hold of the other directors and that you want to resign, that it didn't happen, etc. And on a case-by-case basis, that and then do the resignation. But I don't want to give information that is contradictory to what they do specifically, but I know in the past, in these instances where none can be contacted or there's deceased directors, an affidavit would be acceptable. So I think you can go that route, Santi, and then just check if this company still exists in the first instance, and then secondly, do your affidavit in trying to do the resignation.
Okay, Santi, did you get that answer? Okay. Please remember to complete the survey questions. I hope you'll have already completed those 6 easy questions. They're very, very short, and I really will appreciate if you answer them. Is there any other questions that you have? I see Santi's hands is still raised. I don't know if she has a follow-up question or, okay, no, she has left the meeting. Is there any other questions that you'll have? Feldman, do you have a question? Can I take your question?
Yes, certainly. It's just pertaining to the previous matter that was discussed at length in terms of people offering services and charging for it, specifically outside the building there. But my question is pertaining to other companies offering the services, you know, to register your company, to do all of that. So just in terms of the legality of it, you know, because you know, there's quite a few out there. So I just want to have like your input in terms of, you know, is that legal? Is it permitted by you guys?
All right. Yes, it is. But we prefer to work directly with the customer, with the entity owners themselves. Please refer to our terms and conditions on our CIPC website, especially if we call it an intermediary, because you act between your client and us. We have got very detailed responsibilities for these intermediaries. If you offer a service like that, we hold you liable if incorrect information was submitted to the CIPC. If we have got challenges on filings, we will involve you. So please read the terms and conditions. It clearly states also a provision regarding intermediaries and your responsibilities when offering services.
Okay, excellent. That's good stuff. And then just one last thing, in terms of these intermediaries, is there like a place whereby you can register with you guys to say that, you know, is there
No,
a database or nothing like that?
Nothing currently. We have stopped. We had what we call the third-party model, whereby it was a biometric system. We have deactivated that function, that channel, due to an extremely low uptake.
Oh, I see. Okay. Okay. Thanks so much for the information. We'll read up on that intermediary. Thanks.
Jaco, your question, please. Jaco?
Yes, can you hear me?
Yes, I can hear you.
Okay, I just want to find out, with regards to shelf companies or companies that were registered but never traded, I know that I think it's section 30 of the Companies Act requires that each year a company must prepare annual financial statements. What are the requirements in terms of dormant companies? Are they also still required to actually prepare financial statements then?
Okay, Jaco, in terms of the Companies Act, there's no definition for a dormant company. So meaning, even if you're a dormant company, it means you have not actively been trading, you still are obliged to follow every single legal obligation in terms of the Companies Act. So therefore, best advice, if companies we've got something called survivalist registration in South Africa, meaning people register companies without having an economic opportunity in the hope of getting it. So we've also got a very high deregistration rate. So if the company doesn't get off the ground, apply for voluntary deregistration. Because even if you are dormant or inactive, you still need to file annual returns. You still need to pay the cost. If you're a public company or a private company that opted to have audited financial statements, even though you haven't traded, you are obliged to follow and to complete those legal obligations. So you firstly need to go and check what type of company it is, what does the MOI state as to what its compliance obligations will be towards the CIPC, regardless of its status.
Okay. Thank you so much. I just want to, so basically it's a standard MOI. It was a 2015 company that the opportunity was never taken up. So it's completely, if you can say in that sense, dormant, no income, no liabilities or expenses, but it never actually prepared financials. It never filed its annual returns. So meaning it's now actually in the process of being deregistered due to the non-submission of the annual returns. So what is the consequences of a company not actually following, even though, you know, the director is of opinion that it's a dormant company, if he decides not to file its returns or not to prepare financials, what is the consequences?
It will depend on the circumstances of the company upon us initiating a compliance and enforcement investigation. Please remember that Directors are liable for the actions and inactions of their companies, even after deregistration. So it will depend on the circumstances, because this company may have been dormant, but for some reason there may be something that they did that harmed the environment, or its positions, it can depend. So that's why they need to comply with the requirements,
Yeah.
regardless.
So basically the company was registered the prospect of buying a property, but the property was never bought. So the company just lying in the air, it's just there, and nothing happened to it. No changes to the directors, nothing. It's still the same as from day one of the registration.
Okay,
So
they've got two options. Sorry, I'm going to intercede quickly here. They've got two options. They can either have to continue in the annual return deregistration process in order to get finally deregistered, or they can go and file all the outstanding annual returns and then FAS, and then apply for voluntary deregistration, because voluntary deregistrations takes quicker than annual return deregistrations. But the legal liability of those directors are still the same, regardless whether it was an AR deregistration or a voluntary deregistration. The Companies Act doesn't make a distinction regarding directors' liability based on the reason for the deregistration. The consequences are the same.
Okay, but there's no problem. There's no consequences as such for leaving the entity to be deregistered automatically by the CIPC, because I know that the Companies Act still requires you to file a return. So if you don't file your returns, you're actually out of line with the Companies Act. Then you're not compliant with the Companies Act, because the Companies Act requires every company to file a return. So if you leave your company, you don't file returns, aren't you in a risk of getting a compliance note or being,
No, because final deregistration is a sanction for non-compliance with annual returns.
Definitely.
You can't have double jeopardy.
Okay, so there's no risk just leaving it to be deregistered automatically.
Jaco, if you've got any further questions, I think you need to log a ticket with very detailed, specific questions regarding your matter. The deregistration team and the specialists will take it there, because I think you are delving very deeply into the consequences that may not this may not necessarily be the forum in order to get that minute detail.
All right. Okay. Thank you so much.
Thank you. You're welcome.
Okay, the next question from Mzi. It will be our final question. Mzi, can I have your question?
Mzinduna.
Are you there? Okay.
Hello, yes, I'm there, but I don't have everything. I'm fine with everything. I don't have a question.
Thank you.
Okay, then you can put down your hand. Okay, I hope everyone has filled in my survey. As I said, my survey question link is on our website. Please remember, if you have any other question, please log a ticket.
Hello, can you hear me?
Yes, I can hear you.
Sorry for that. This is Mzinduna.
Oh. Hello. What I was saying is that
am I able to proceed with the question? Yes.
Yes, please ask the question, because she tried to get off. Maybe it was a connectivity problem. Let's give you an opportunity. Just raise your question, please.
Thank you. It's just a follow-on question with what was just discussed with Jaco. If your company had been dormant for a while, especially with the requirements of the audited financial statements, is a confirmatory affidavit with a commissioner of oath sufficient from a legal point of view to state that the company has been dormant and as a result cannot have audited financial statements? Thank you.
Okay, to be quite specific, that deals with audited financial statements. Firstly, that will depend on the company type itself and whether the company, private company, has opted to be audited. Please log a ticket for financial statements it's a compliance matter and they will advise you from there. Unfortunately, we cannot answer it at this forum.
Thank you.
Okay, ladies and gentlemen, we have now come to the end of this webinar, and I'm confident that the distinguished speaker has communicated valuable information to you all. I am confident that you have at least been educated on this virtual platform and that CIP's innovative technology, fresh energy, and novel efforts have made transacting with CIPC much easier and quicker for you. Your engagement and feedback will be invaluable in facilitating our further webinar topics. Remember, if you have any queries, please log a ticket on our website, www.cipc.co.za. It's our QRS system, and all your inquiries will be answered. Please get your ticket number when you're emailing us. We look forward to a fruitful transaction. Thank you very much.
Thank you all for your fruitful engagement, and also extend a very thank you to our colleagues, Advocate Krista Klo and Advocate Lucinda Steenkamp, for participating in this value-adding webinar. I thank you all. Looking forward to seeing you in our next webinar.
Goodbye.
Thanks, everyone. Bye.
Thank you, everybody. Bye.